Let's take a look at constitutional structure and control. The Constitution establishes a federal form of government, the federal, national government, and the governments of states. This horizontal division of authority is known as federalism. The powers of the federal government are spelled out in the Constitution, but the powers of the states are not. On the surface, the 10th Amendment appears to establish two discrete zones of authority and one zone of rights. Beginning with the latter, the amendment protects individuals from both state and federal authority in some circumstances. This is also accomplished by the many rights explicitly protected by the Constitution and its amendments. As to the relationship of the states to the federal government, the Constitution is not clear. Two primary theories about the relationship of federal and state authority have been asserted to define the federal-state relationship. The first is dual federalism, the federal system of government where both federal and state governments are sovereign with different and occasionally concurrent jurisdiction. The second theory is hierarchical federalism. This approach positions the federal government as supreme, with the states possessing only residual powers not possessed by the federal government. As the authority of the federal government expands or contracts, the authority of the state changes in the opposite direction. Because the federal government and state governments often regulate different areas, each must establish its own agencies to administer and enforce their own laws and policy. Accordingly, there are a multitude of agencies, each with its own popular rules and procedures. In addition to federal and state agencies, many local governments have their own agencies. Finally, note that although the dual and hierarchical federalism models provide a framework for understanding the authority relationship, the federal and state governments often cooperate. This form of partnership is commonly known as cooperative federalism. Cooperative federalism, as a descriptor, is not a structural or legal model. It is instead a relational model. A horizontal division of power, known as a separation of power, also exists. The doctrine of separation of power divides the powers of a government into three branches: executive, legislative, and judicial. At the national level, the executive branch consists of a president of the United States, the president's subordinates, and agencies. At the state level, it's comprised of a state governor and his or her subordinates and state agencies. The executive branch of government is responsible for administering and enforcing the laws of government. The legislative branch is represented by the Congress of the United States at the national level and the various state legislatures at the state level. The legislative branch is responsible for the creation of law. A written law enacted by a legislative body is also called a statute. The judicial branch is represented at the federal level by various federal courts, with the Supreme Court of the United States as the highest court. Each state also has its own court system. The judicial branch is responsible for administering justice, resolving disputes, and interpreting the law. The framers intended for courts to be free from political pressure, conventional wisdom, and the waves of popular opinion. Normally, one governmental branch may not exercise the responsibility of another, even if the two branches agree that one is to delegate a particular function to the other. This maintains a balance of power. The branches also check one another. That is, rarely does the Constitution establish a procedure whereby a branch may exercise its authority without being reviewed or authorized by another branch. The framers of the Constitution of the United States embodied these principles into the Constitution. The purpose of the doctrines of federalism and the separations of power is to prevent the centralization of power. This checks and balances system protects civil liberties. The concept of separations of power is important to administrative law.